I now call Robert Brown.
Thank you very much, Presiding Officer. Could I say, first of all, that Lord Gill has produced an extremely weighty report, I have to say in several senses of the word. I don't know why it has to be printed on such heavy paper, just a minor issue to the side on that one. But it is a report which does identify a number of very serious barriers to speedy, affordable and effective civil justice. I suppose I might be expected to take this view as a lawyer by profession, but access to justice, and particularly civil justice, is a central requirement of a functioning democracy. Indeed, redress against injustice and procedures for resolving disputes between citizens or between the citizen and the state were amongst the earliest functions of the state. Today, the courts are only one of a wide range of bodies concerned with resolving disputes. Many trades and professions have got complaints and dispute procedures. Many services are underpinned by insurance and arbitration arrangements. There are public service ombudsmen, there are mediators, there are advocates in the advocate sense as opposed to the lawyer sense. And there are in-house advice services, Citizens Advice Bureau, campaigning newspapers and many others. Access to the courts is supported, though less than it once was, by state legal aid and by the work of the trade unions. But the central thread and the ultimate recourse has to be to the courts. And I say that against the tendency to say, well, arbitration, various other devices. The courts have to remain the central recourse. They are the third arm of government. They're jealously and rightly protective of their independence, and they're able to give the sanction of the law to their judgments and to enforce their orders if need be. The courts have to be a bulwark of our democracy, and an independent legal profession, of which, like Mr McCaskill, I'm also proud to have been a member, accessible to everyone, is the necessary precondition of judicial independence. Now, Lord Gill's report is highly controversial on a number of fronts, but it will define the debate in the weeks and months to come. It would be wrong today to try to give a definitive response either individually or across the chamber to a very lengthy report, and I do stress the point that I think we have to, despite the desire to move forward with it, make sure that we get the implementation detail right. If there's one thing I've learned as a MSP, indeed as a minister before that, is that 1% of the job is the good law. 99% of the thing is making it actually work in practice. I think that's an actual caveat we have to be conscious of. But I do want to raise a number of points. Lord Gill presents his report as something to be taken as a whole, not cherry-picked, the point I made earlier. But I do think, while the recommendations are interconnected, I do think there are separable strands to be considered nevertheless. There are some matters, Presiding Officer, to which Liberal Democrats give their unqualified support in principle and which do not necessarily raise major financial issues. These include the necessity to phase out routine reliance on temporary judges and sheriffs, because that distorts the system, it reduces the perceived independence of the bench, and it may undermine our adherence to basic ECHR principles, to which, unlike Mr Aitken, I do give considerable adherence. The widening of certain court powers, notably the definition of title interest to sue, to give a broader range of organisations the right to take up or enter judicial review proceedings, I think is important. Example might be the right of a body like Age Concern Scotland to raise proceedings affecting older people as a group, rather than have to identify a nominal individual petitioner to bring the action. And that will significantly enhance the accountability of government and of other public bodies. And I think it's also sensible and long overdue to permit the taking of actions of reductions and proving the tenor of lost documents. I know slightly esoteric actions, but they do happen from time to take them in the Sheriff Court. The extension of in-house advice services like that pioneered in Edinburgh, and now I think with some increasing support from the Scottish Government going across the country, is also a very important aspect. And we've touched, of course, on the Mackenzie Friends aspect. I think the point hasn't been made yet, but a separate investigation is identified by Lord Gill of issues around the complex issue of the cost of justice and the implications of awards of expenses, such as the growing gap between the cost of litigation to a party and the expenses awarded on success, and not least the recoverability of after-the-event legal expenses insurance premiums, I think do deserve very close examination, which Lord Gill and his committee have not had the time to do. And indeed, the duty on opposing experts to try to agree their positions is also a valid direction of travel, the one I suspect may prove also to have cost implications and indeed time implications as well, if my own experience in these matters is anything to go by. And the introduction of a court discretion to make a protective costs order or to put a cap on expenses in certain cases, raising significant issues of public interest, I think has also got some potential. Lord Gill rightly indicates the conditions and likely limitations of such orders, because there is actually an issue of not making it over easy to go to court either. You want people to settle their case if you possibly can, and the balance of the system has to reflect that. But nevertheless, there is a perceived injustice where public authorities are seen to have, in a sense, a bottomless state-paid pit, if you like, to raise or defend actions against private individuals, paid for by the taxes contributed to by that individual and by others who don't support the government action complained of. And we've seen this in the context, I think, of school closures and other sorts of actions of that sort. I believe my colleague Ross Finney is going to develop this point in the context of the Aarhus Convention. Now, there will, too, be much support for many of the technical aspects of the recommendations. The docketing of a case to a particular sheriff, the stronger powers to dispose of a case summarily are important, and the enhanced case management powers for the court will also be vital. Though I'm bound to say that when I was in private practice, I sometimes felt that sheriffs had forgotten the pressures of a busy office and a heavy caseload when one asked for continuations on the continued adjustment role, normally regarded as the last salvation of many a solicitor. The serious point is that there's sometimes a balance between the over-heavy sanction of dismissing a case or of granting decree on the one hand because of a one-off procedural error and not letting the case drag on the other because the lawyer for one side or the other, or sometimes both, has taken his eye off the ball. The strength of the Scottish system was always seen to be the fact that well-drafted pleadings focused attention on the issues in dispute at the heart of the case. But in many cases of small value or limited complexity, that may be better done by the judge adopting a more hands-on approach to ensure speedy identification of the issues and a proof limited to the matters in contention. But I want to finish, Presiding Officer, on the biggest issue, which clearly will be costly, and that's the reform of the court creation. And I think doing some of these sort of things need, in particular, close examination, possibly by the Justice Committee. And the government, I think, have to give some sort of direction to this by indicating fairly early on their estimates of the cost and the likely cost of these matters and the chances of early availability of funding. And I did note the Cabinet Secretary's comment about the matter of a different financial climate, which I think we're all conscious of. We do have substantial concerns about the loss of access to the court by certain of the changes. We've talked about the personal injury court, and I agree with Bill Aitken. There's no particular reason why that should sit within Edinburgh Sheriff Court, which actually, I think I'm right in saying, because of the presence of the Court of Session, attracts less personal injury business than most of the other courts in the country. And are we, in fact, talking about a downgrading of the importance of family actions and children's hearing referrals if they're thought to be particularly suitable for the lowest court? Some of these cases are the most anxious and challenging that any lawyer can face. Now, in conclusion, Presiding Officer, Lord Gill doesn't mince his words. He talks about a system of civil justice seriously failing the nation, a service that's slow, inefficient and inexpensive. They deserve thanks for a thorough and innovative report. We now have to consider it, decide how much resource needs to be allocated to reform, and also concentration on the detail to make sure that it fits the needs of all parts of this multifaceted country of ours.
I now move to the debate, and I call Alistair Allen to be followed by Cathy Jameson.
Thank you, Presiding Officer. The Scottish Government has already started to improve on our civil justice system. Scotland rightly prides itself on the institutions of its distinctive justice system, institutions which, of course, remarkably survived the long adjournment of this Parliament. But there is a wide and, as is obvious, a cross-party acknowledgement that those institutions are now creaking under the weight of their work and are in need of serious reform. That is clearly the view of Lord Gill, and I am not going to perjure myself by claiming to have read